Hey, sorry, this one's in two parts. I had a little bit of an issue there, but we're going to talk about confidentiality next. Confidentiality is Section B in the ACA Ethics Code. I believe it's section or Part 4 of the APA Ethics Code, but they cover the same material. All right, so the reason that we discuss confidentiality and privacy is to really protect the client and respect their rights. The clients really have the right to determine what they disclose to you and then to enjoy the fact that you are respecting their privacy. You should not be soliciting private information just because you're curious. So if you're seeing them for maybe like stress management or bereavement, it's really none of your business, their sexual history or substance abuse history, unless it's pertinent to what you're trying to work on as a therapist. So just because you are curious does not mean that it's beneficial for treatment. And also, you have the right or the obligation, of course, to refuse to disclose confidential information without the client's consent, unless there is a legal reason, which we'll talk about in a second. The right to privacy also extends to prospective clients. So let's say someone calls you and they say, I'm having a lot of trouble with my spouse, blah, 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 and they decide not to pursue treatment. Just because you never entered into a full therapeutic relationship with them does not mean that you get to tell your best friend, you'll never guess who called me to talk about their spouse, right? You still treat them with the same level of respect regarding treatment and therapy, confidentiality. And as soon as you meet them, so before you even get into the intake questions, it is your job to tell the client that what the limits are of confidentiality. So you talk about it, it's also in writing and your informed consent. And everything you tell me is between you and me, except this, this, and this. And we'll talk about the exceptions to that. It's important that clients understand that confidentiality is not absolute. There are limits. It doesn't fall into the same kind of legal jurisdiction as a confessional, for example. So, a Catholic priest can refuse to tell police what was heard in a confessional. It does not extend that far for counselors, and we'll talk about why. So basically, things that you hear from your clients are kept in confidentiality unless their following criteria are met. So if the client is threatening harm, serious and foreseeable harm to an identifiable victim, then you could break confidentiality. If there is any idea or any suspicion of child abuse, you can break confidentiality, and also end-of-life issues, which we'll talk about in a second. So if the client is suicidal and they then pose a danger to themselves, you can break confidentiality. If they are threatening harm to identifiable victim or group. So it's one thing to say, someone cut me off today and I wanted to kill them, right? That is somewhat threatening and aggressive. That's different than saying, I'm having fantasies about killing my boyfriend, right? I have a knife under my pillow and he sleeps next to me, and sometimes I think about really hurting him. That is an identifiable victim. And if you believe that that person is in harm's way or potentially in harm's way, you have an obligation to break confidentiality. If they say, I hate, I don't know, I'm trying to think of an obscure, I hate Irish people. Okay, that's not an identifiable harm intended toward a certain group, as much as if they say, I want to blow up a mosque, this particular mosque at this particular time, right? That is an identifiable, foreseeable harm to a specific group. Now, we talked about this a little bit before, but them telling you that they have committed crime in the past is not reason to break confidentiality. So even if they disclose to you that they've murdered someone and that person, maybe someone else has already gone to jail for that, you don't get to break confidentiality unless they say, and I'm going to do it again to this person. Because then you have an identifiable victim. There's something that there's a crime that you can prevent. So Obviously, from a moral perspective, that's a very difficult position to be in if someone else has been accused of a crime that they didn't commit, and you know who did. But the ethics code is pretty clear on what your job is in that situation. Now, if you decide that it's worth losing your job to go forward, then that is, of course, your choice. You wouldn't go to jail, of course, for telling the police what you know, but you might lose your job, as in lose your license. Um, Suspecting abuse or neglect of a child or other vulnerable individual warrants breaking um, confidentiality. And then most states have duty to warn and duty to protect laws that are pretty much just what I said. You are a mandated supporter or a mandated reporter, excuse me, in the state of Oklahoma when it comes to child abuse. And so if you suspect, then you have a job, you have the right to report that, actually an obligation to report that. Um, I will say one tricky component of this is with minors. That's where most of my experience comes from. What is considered a danger? Because adolescents do really stupid things, and you will be at a crossroads at some point, most likely, if you work with adolescents, on what constitutes harm as far as telling parents. You don't want to tell the parents everything the child tells you because they will not trust you. However, if they are doing something really risky, then you might feel that it's warranted to tell the parent. And so that gets tricky. Is smoking pot a good enough reason to break confidentiality? That's for you to decide. Is having sex as a 16-year-old, reason to break confidentiality? Maybe not, maybe yes if they're 13, or if the partner is a lot older. So there's just a lot of factors, and that's kind of where your value system will come into play, because you'll decide what is kind of kosher and what's not for an adolescent. When it comes to end of life decisions, euthanasia type discussions, it is illegal in Oklahoma to aid someone in assisted suicide, and knowing that they are going to do it and not reporting it is the same as any other type of suicide as far as in the eyes of the law. So if a client who's 30 tells you, as soon as I leave here, I'm going to jump off a bridge, and you don't report that, you are complicit in their death, and there actually can be criminal action taken against you. In Oklahoma, the same applies for assisted suicide, even if they are very old and very sick. Different states have different rules, but Oklahoma is pretty strict on that. Probably not too surprising from the political perspective for Oklahoma being so conservative. But yeah, there are some issues there. You just need to be aware that you can be held criminally responsible if you do not take steps to prevent that from happening. It's viewed just like murder in the state of Oklahoma. And there is a link there when you click on your actual PowerPoint on Blackboard. You can read through the different state laws regarding euthanasia. Similarly, with HIV and other contagious life-threatening diseases, as far as HIV goes, it is still considered a terminal illness. We have come a long way as a society as far as treatment for HIV and AIDS, a much longer, sustainable, high quality of life, but it is still eventually what will kill you, most likely. I mean, obviously, you could, get hit by a car or something, but eventually, that is what will contribute to your death. And so if you have HIV, or if your client has HIV and they are willingly and knowingly potentially spreading it to others, that is them inflicting very significant harm on others. And it falls under the same category as any other type of threat. So if you know, for example, that they are living with someone, a significant other, and it's a serious relationship, and that they are having sexual intercourse, and they're having unprotected sexual intercourse, and the other person doesn't know that they are HIV positive, you can break confidentiality. And I do have the laws there for you in your PowerPoint if you are interested. But now if they are just sleeping around very, casually, and you don't know the names of who they are sleeping with, then you can't do much about it. But you can encourage them, of course, to be forthcoming with that information. But if you do know the other person involved, then you have the right to break confidentiality. Now, when the court system gets involved, things get a little bit trickier. Um, so basically, you try to inform the client that I may have to break confidentiality if this happens. So the first thing you would get most likely is a subpoena from a lawyer. And when that happens, you can go to your client and say, hey, I got a subpoena. Do I have your permission to share information with them? And then you would do just a regular release of records like you would if you were sending information to their GP. If they say no, that they don't want you to talk to that lawyer, then you have the right to tell the lawyer that you cannot disclose that information because it's covered by confidentiality. Um, Now, if the subpoena turns into a court order, which comes from a judge, then you kind of are out of options. You pretty much have to give over records. And so that is a legal issue. Now, you can choose not to, but you can be in contempt of court and you can go to jail for that. So you should try to keep your client informed of everything that you send to the court. And if you have to testify, even if the client doesn't give you consent, then you should try to limit the amount of information disclosed to only what is most important. So you don't have to send every single note you've ever taken on that client. You can try to limit it to what's pertinent just in that case and not give anybody extra ammunition to use against your client. Um, but yeah, it's a tricky deal. Subpoenas are serious. They You don't have to respond right away, but you do have to respond. And I've mentioned this before, but when you are licensed, you will have liability insurance. Agencies will require it, but you should, even if you're in private practice by yourself. And with that liability insurance comes the option to talk to their lawyers. They have lawyers on retainer who will walk you through the legal process, and then you document all of that, and they will tell you what you have to give when. So just know that you don't get the option to ignore subpoenas, that you should have support in place through your liability insurance, and you can kind of limit what you send until you get that court order, and then it might be more specific. Um, the other thing to think about too in your office setup is who knows what. Secretaries, the people who do front end billing, people who check people in, they have a lot of information. They're usually fielding the calls that come in from people, assigning them to counselors. They are there for the billing aspect. And so it's important that they are aware of what is confidential and who they can talk to. They should not be going home and talking to their friends either about who came into the office today and what kinds of issues they're having. If you work in a setting where you will be discussing cases with other professionals regularly, that needs to be in your informed consent. The client needs to be aware of that. And then with insurance, they will have access to the diagnosis code. They should not have access to much more than that, other than maybe a treatment plan, depending on the insurance. But you aren't sending them your progress notes every week, most likely. If someone else pays for services, let's say that you have an emancipated child, like a 25-year-old, and their parents are paying for therapy, it does not matter that they are paying for it. You still do not break confidentiality. So who's paying is of no importance, really, unless it's the guardian and you have a minor. So third party does not matter. They don't have any extra right to information just because they are paying for it. We are constantly kind of changing how information is shared as far as HIPAA compliance. There are obviously some ways you can email now that are safer than they used to be. You can encrypt files, things like that. Faxing is still considered secure, which is kind of ironic because who knows what's on the receiving end of a fax when you send it. But yeah, with technology, we're getting better and better about ways to transmit records. And just you can Google, HIPAA compliant email, and you will find a lot of different options for that. When it comes to deceased clients, you still don't get to break confidentiality, so you still don't get to call up the wife and tell them all the things they said about them after they've died. There might be exceptions to that when you're talking about perhaps a criminal investigation, things like that, but they would still have to go through the court order process to get the information from you, even if the client is deceased. If you're interested in doing group or family therapy, the rules change a little bit because you cannot guarantee confidentiality when you have a group. Um, you can encourage it and you should encourage it, but you can't promise that no one from that group is going to go home and talk about what other people said in group therapy. With couples therapy and family therapy, it's important to be clear up front about who the client is. So let's say you're seeing a child and the child is the client, and every once in a while you bring in the parents. Well, the child is still the client. Same thing with couples. Let's say you're seeing let's say you're seeing the wife, and that's the regular client relationship with her. And then every once in a while, husband comes in. Well, unless you're going to enter into a new situation where you're going to see the couple together every time, the wife is still the client and her confidentiality would still be respected. You wouldn't share with the husband things that she wouldn't want you to share just because he's in the room. If you're seeing a couple together from the get-go, then they as a unit are the client. And there are kind of more specific rules about how you share information between them. That's not really the point of this class, but just know that it's important to be upfront with the client and from the get-go about who is the client and what are the expectations for confidentiality. Um, I talked about this a little bit already, but it's important that um, you protect children and their expectation of confidentiality unless there's a good reason not to, as far as with their parents or their teachers or whatever. It's important that you really respect their privacy too, unless they're in danger or someone else is in danger. When it comes to records, um, keep them safe, keep them away from other people. If you're going to record a session or have someone else observe, you need to make sure that you get permission ahead of time to do that and don't make the client feel pressured to do that. If the client asks for copies of their records, they have the right to that. However, you can be judicious in what you send them. You don't need to send them every progress note you've ever taken on them. You can send them treatment summaries, diagnostic information, because it's really not beneficial for them necessarily to read every thought you've ever had about them. Um, and if you do withhold, you have to have a good reason and make sure that you document that. Um, if someone else will be in danger because of what you send them, or you might harm another individual. Uh, you just have to be clear about that. And again, that's something that I would seek guidance from your liability insurance in regards to what you should send when. You want to assure what's called reasonable future access to your records. So you keep them in a somewhat coherent system, in a file cabinet in your office. That's reasonable future access. Now, if your office catches on fire and you lose paper records, I mean, that happens, right? You can't prevent that. But as long as you've taken steps to try to avoid that, keeping them in a dry, safe office. That's the best that you can do. Definitely need to shred or otherwise safely dispose of records when you're done with them. 7 to 10 years is kind of a safe estimate for how long to keep records. I would keep them longer when you're talking about particularly tricky cases like child abuse and things like that, suicide, sexual harassment, because you just never know when that stuff's gonna pop back up. And then finally, when you're designing your office, you want to try to assure soundproofing as much as you can. Sometimes people use those white noise machines out in the hall, things like that. Train staff in what they need to keep private, um, how you're going to respond to requests for information. Be thoughtful about how you use technology, such as teletherapy, which we'll talk about more later in the semester, and things like that. Leaving messages. So if a client calls you and you call back, you can say, this is so and so. I received your call. I'm just calling you back. Give me a call when you get a chance. That's fine. But I wouldn't say, this is Sarah, I'm calling you back about your difficulties that you're having with your spouse, blah, blah. You don't need to leave all that in a voicemail because you don't want that to fall into the wrong hands. And as far as texting and cell phones go, if your client is comfortable with texting, you can do text reminders and things like that. If you're doing therapy full time, I would not recommend giving out your cell phone number unless there's a really good reason. But yeah, I think texting for appointment reminders and things, Google can do that for you. There's lots of different mediums to do it that way. That's all for that.